Good evening, our Patriot family, and welcome to another episode of the Fight for Patriotism, where we discuss the Constitution and how it will help us get our country back to where it should be. On tonight's episode, we will discuss the First and Second Amendment. I'm your producer, host, and brother ▲ and with me is your patriot brother, angry conservative. I'll say the Bible verse of the day, play my introduction, and then we have a question to get things started. The Bible verse for Thursday, July 14, 2022 is, "For no word from God will ever fail." Luke 1:37 NIV.
We need you now. We need you now. One day, one day, one day, I hope you see the truth. This puppet show stays on because of you. We've been dancing with the devil way too long. I know it's fun, but get ready to pay your dues. Oh God, come back home. This crazy world is filled with liars and abusers. We need you now before we're too far gone. I hope one day they finally see the truth. God, we need you now.
Good evening, everybody. All right.
How are you doing today, brother? And what's your question you had?
All right. I'm doing great, Zach. And the question is, does anyone in the chat, and Zach, you can't say anything because I've already told you the answer. So that does anyone in chat know where the Bill of Rights were derived from, where they came from? We're going to give you a little bit of time. Me and Mr. Zach will actually speak for a little bit, but does anyone in the chat actually know where the Bill of Rights were derived from? Zach, how have you been, my brother? Because I'm getting in my teacher mode again. And hello to everyone in chat. Tom, that's part of it. Tom has part of it. You can put Tom's message up, his comment up. That's part of it. There is also another part of it. Yeah, we got the Zach attack with us. And the other part is actually from the English Bill of Rights. And it is also part of it is from the Virginia 1776 Declaration of Rights. So our Bill of Rights are combined in a combination of about 3 different things. So, yes. But yeah, I don't know why they would want to take the British Bill of Rights, because the British didn't have a right to the Second Amendment. Just saying. But Tom was right. Basically, the Magna Carta was the original Bill of Rights for the United States. But this is why I love teaching this. This is why. Yes, what Ghetto said. please, if you can help our brother Zach, please do so because he is putting out great information. All right, Zach, what do you... All right, one more question. The Bill of Rights. How many are a part of the Bill of Rights? Is it all 27 or is it a certain number? That's another good question. Is the Bill of Rights for the United States all 27 amendments or is it just a certain number? Yes, Tom, Mr. Tom's on the ball. Tom knows this stuff like the back of his hand, and I love that he's in the chat. He helps us greatly. Yes, it's the Bill of Rights is the first 10, but we will do all 27. But right now we're gonna do the first 2. Zach, if you want to start pulling up the video, and I am actually going to read what the First Amendment says so we all know. Hey, Garrett, the First Amendment to the United States, the Constitution of the United States. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peacefully to assemble and to petition the government for redress of grievances. Zach, are them rights being slowly taken away in this country? Hey, Crystal. But yes, we do have a couple of videos. One about the First Amendment. All right, let's see how... Go ahead, Zach.
Look at section 230.
Now that very good. Zach, I didn't... But the thing about it, YouTube, Facebook, and all of these companies, they're not part of the government. They're private entities. Yes, they are. They are supposed to be private entities. That isn't supposed... So there's the actual amendments only pertain to the government. It does not pertain to companies and citizens. There's a difference. So that's why we need to, that's why I want to address these, so people actually know that. Because I couldn't say up here and say something bad about Zach that's not actually true, because Zach could sue me. So, but I can say FJB all day, so, and he can't do a darn thing to me. So there's a difference. Yes, please hit that like button for this, brother. All right, Zach, let's get to this, to the First Amendment.
Today, I'm learning more about the First Amendment to the U.S. Constitution. The First Amendment is one of the most important amendments to the Constitution, if not the most important. It reads, "Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances." To learn more about the First Amendment, I talked to 2 experts. Erwin Chemerinsky is the Jesse H. Choper Distinguished Professor of Law and Dean of Berkeley Law. Michael McConnell is the Director of the Constitutional Law Center at Stanford Law School and a Senior Fellow at the Hoover Institution. Professor Chemerinsky, there's a lot going on in the First Amendment. Can you tell us a little bit more about why the framers chose to protect these rights in particular?
The historical background of the First Amendment of the Constitution shows why the framers wanted to be sure that all of the liberties in the First Amendment were safeguarded. Let's focus on freedom of speech and freedom of the press. In England, there was, after the printing press developed, licensing, so that anyone who wanted to be able to publish anything needed to have a license from the government. Such licensing was seen to be inconsistent with freedom of speech, freedom of the press, for that matter, freedom of thought, freedom of inquiry.
Interesting. Okay, so there are a lot of essential freedoms that are packed into this First Amendment, so much that it's almost amazing that we're going to attempt to talk about them all in one video. But if we dial into freedom of speech, Professor McConnell, what is freedom of speech? Does that encompass some things and not others?
Freedom of speech was actually less important to the framers than the freedom with which it was coupled, which is the freedom of the press. And the reason for this is that speech that can reach large audiences is much more important to the individual, but also dangerous to the state than mere speech. When you speak, only those people within hearing range can hear you. But when you are able to use Gutenberg's fantastic new technology to publish your sentiments and distribute them widely, maybe even over the entire country or across the Atlantic and reaching hundreds and thousands of people, now that is powerful. And no wonder, so you think about how the American Revolution was won. This required spreading the word. It required gaining converts and telling people what their grievances were. To a very great extent, this was done through the mechanism of the printing press.
When you ask the question of what's freedom of speech, there's implicit within it the issue of what do we mean by speech? Ultimately, the answer to your question is that the First Amendment in protecting speech broadly safeguards the right to express one's ideas, but it's not absolute. The government can restrict expression if there's a compelling interest.
All right. I'm going to ask this question. Can you actually say fire in a crowded theater when there actually is no fire? Legally, can you say that? Zach, what do you think? Can you actually say that? You say no. Put Devil Dog's answer up. Yes, you can. You will not be held criminally responsible if anything happens, but civilly, you can be held responsible for it. Yes, you can actually say fire in a crowded theater and not be charged criminally, but civilly, you can be sued if someone gets hurt. So, yes, you still have freedom of speech. Yes. Devil Dog is a very knowledgeable man. This is why D-Dog and Tom, I love having them in chat. But let's get back to the video. I wanted to... Exactly. So...
Can you say more about that?
The Supreme Court always has been clear that freedom of speech is not absolute. The court has said that there are certain categories of speech that are unprotected by the First Amendment. Incitement of illegal activity is a category of unprotected speech. The court has said this requires showing that the speech was directed at causing imminent illegal activity, and there was a substantial likelihood of imminent illegal activity. Another example, obscenity is unprotected by the First Amendment. The court struggled for years with trying to define what is obscenity. Maybe the low point in that is when Justice Potter Stewart said, I can't define it, but I know it when I see it. There are also these categories of speech where the government can prohibit, even punish the expression.
That's where most of the limitations on the freedom of speech and of the press come from, is in order to make sure that we don't hurt other people's rights through the use of our own. So an example of that, the government can prohibit speech which incites violence against someone. So if you're making a speech and calling upon the crowd to attack somebody's house or their person, that can be punished and prevented as an incitement to violence. And you can see how that follows from the logical idea of freedom of speech being a natural right and therefore limited by the rights of other people.
So let's turn our attention toward the freedom of religion part of the First Amendment. So the first thing that the amendment says is about establishment. So what does this establishment clause prevent?
The language of the First Amendment is important. It says that Congress may make no law respecting the establishment of religion. Since 1947, the Supreme Court has said that it also applies to state and local governments. And the Supreme Court has said this means that the government cannot act with the purpose of advancing religion.
To the founders, this was a very clear legal concept, namely it was the established Church of England. In the statute books, in the law, the Church of England was referred to as, and I quote, the church by law established. What did it mean to be established? First of all, it meant that the doctrines of the church, the 39 articles of faith of the Church of England, were voted upon by Parliament. So the doctrines, the liturgy, the text were all adopted by law. The established church was the government's church, and it could be used, and from time to time was used, as an instrument of government or as an instrument of politics. And this is a way in which the government is able to have a powerful influence on the way in which values and opinions are inculcated. It's one of the most important ideas of the established church, especially in the 18th century, was to teach that there's actually a religious obligation to obey the law and to recognize the king as a supreme leader in matters of both church and state. And the framers' experience with this was extremely powerful.
That's because the framers were aware of the religious persecution that had gone on in other countries. They were aware of the evils that occur when the government becomes aligned with a particular religion.
The principal reason why many of the colonists had come to these shores to begin with was to escape the oppressions of the established Church of England back home and to come to a place where they would be able to exercise the freedom of religion for themselves. And the main opponents of the established church were not anti-Christian or anti-religious people. They were the most religious people, and their view was the government should stay out of our church, that we will decide what we believe for ourselves. We will control our own church. We will write our own liturgy. We'll decide what version of the Bible we're going to use. We'll choose our own ministers. Thank you very much, government. Stay out of it. Leave us free to practice our religion without having this kind of an establishment.
So, for instance, a county in Kentucky required that the 10 Commandments be posted in all county buildings. The Supreme Court said the 10 Commandments are religious scripture. There's no secular purpose for having the 10 Commandments posted in county buildings. The court declared it unconstitutional. The Supreme Court has said the government can't act where the primary effect is to advance or to inhibit religion. So, for example, there can't be prayer in public schools. Even a voluntary prayer in public schools is impermissible, because the court has said that the primary effect of having prayer in public schools is to advance religion. The court has explained children will inevitably feel pressure to participate. This coercion violates the Constitution.
So the First Amendment then prevents that kind of intermingling of the government and the church. This is, I guess, the key idea of separation between church and state. But it also says that the Congress shall make no law prohibiting the free exercise of religion. So what does that mean?
Free exercise of religion was the right to practice your own religion. It didn't keep the government from setting up a church, but it did keep the government from requiring you to attend that church, maybe even to contribute to the church, but also kept the government from preventing you from worshiping elsewhere. So the Establishment Clause, by and large, prevents the government from forcing people to participate in religion, and the Free Exercise Clause, by and large, prohibits the government from preventing people from practicing their religion. Those two things work together to enable everyone to worship God in accordance with their own conscience.
Interesting. All right. So we mentioned a little bit about freedom of the press, but there are two other aspects of the First Amendment: the right of the people peaceably to assemble and to petition the government for a redress of grievances. So what is included with the right to peaceably assemble? Are there any situations where that might be restricted?
The Supreme Court has said that under freedom of speech, there's a right to use government property for speech purposes. This is also something that tells the freedom of assembly. And the Supreme Court has said that there are certain government properties that the government is required to make available for speech. Sidewalks in parks. There's other places where the government has more latitude to regulating speech. School facilities, evenings and weekends. There's places where the government can close entirely to speech. Military bases, areas outside prisons and jails. All of these cases could have been litigated under freedom of assembly. Some of the earlier cases explicitly mentioned freedom of assembly. The subsequent cases combine freedom of assembly into the protection of freedom of speech.
I guess that makes sense. But what about something like a march, for example, that might, say, block traffic? That's perhaps a clear case when there is this tension between freedom of speech and assembly and, say, public safety if they're blocking, say, an ambulance. How do you resolve that tension?
Sometime in roughly the 1970s, the court began using a quite different way of looking at the free speech question, in which they said that laws which regulate or prohibit speech on the basis of the content of the speech are, generally speaking, unconstitutional, absent a very important governmental purpose. But the laws that are content neutral and regulate speech on the basis of its time, place, or manner are permitted. So the basic idea here is the government has regulatory authority over speech, but not over what you say, but just over when you say it, where you say it, how you say it.
All right, so the last thing in the First Amendment is the phrase petitioning the government for a redress of grievances. That Congress shall make no law abridging that freedom. What does this mean? How would one petition the government for a redress of grievances?
There are, of course, many ways that people can petition government for redress of grievances. It's the ability to go and testify before a legislative body. It's the ability to communicate with one's legislators or representatives about change. It's basically the ability to go to the government and ask it to change its policy. There were relatively few cases just about the right to petition government for redress of grievances. Again, I think the reason for that is it's been so subsumed into the protection of freedom of speech. Everything one would do by way of petitioning government for redress of grievances is through speech and expression. And so the larger protection of speech and expression has meant that the court hasn't needed to focus so much on this particular right.
Is there anything that you feel people commonly misunderstand about the First Amendment, what it encompasses and what it does not?
One of the most important misunderstandings about the First Amendment is people fail to realize that it like all rights in the Constitution, apply only to the government. Before I took my current job, I was a professor at Duke University in Durham, North Carolina. Duke is a private university. If while I was there, I had criticized the president of the university, and he would order me fired, I could not have sued him or Duke University for violating my free speech rights. The First Amendment doesn't apply because it's a private university. But now I'm at the University of California, a state university. If I were to give a speech criticizing the president of the university or the chancellor of my campus, and I was to be fired for doing that, I could sue. I would sue. Since this is a public university, the First Amendment applies.
So I think the really dangerous thing in our times is that many people believe that they have some kind of a right not to hear opinions that they find offensive. Certainly, college campuses are filled with controversies of this sort. You know, this is something that our Constitution was designed to prevent. Free speech can inflict offense. Sometimes it can be hurtful and insulting, but we as a nation have decided that it is better to put up with that so that we can all be free to express ourselves, to criticize the government, to urge the religious and scientific and artistic ideas that we have, and that it's more important for all of us to be able to do that than it is to be able to retreat to safe spaces and require other people to shut up.
So we've learned that the rights protected in the First Amendment derive from the historical context of restricted speech, press, and religion in Europe that the framers wished to avoid in the United States. Freedom of religion includes both the freedom not to participate in religion and the freedom to practice whichever religion you choose. Freedom of speech extends to all forms of freedom of expression, not just words. But there are limits to what counts as free speech. To learn more about the First Amendment, visit the National Constitution Center's Interactive Constitution and Khan Academy's resources on U.S. government and politics.
Now, that is very interesting. And I seen something. Put the Polarin's message up about government property because I do wanna talk about that situation. No, it's a little further up, my friend. Yes, government property. What I'm gonna say is government property is actually public property, but to be more accurate with that, it's taxpayer funded property. The White House, the Capitol, all of that stuff in Washington, D.C. that they tried to keep us out of for a number of years is our property. We own that because we pay for it every freaking day of our lives. But yes, there are, and Polarin, you're right about no limits with free speech, but I cannot, because with free speech, would you want everybody calling you a certain word like what they've called what we call Jeffrey Epstein or Joe Biden and all of that? Would you really want someone to call you that every day and not be able to sue their ass? That's why yes, free speech. But all right, our free speech, we can say anything to anyone in the government. like how we call, like with the phrase "Let's go, Brandon." I'm gonna keep it PC in case kids are watching. I'm gonna try to keep it a little PC right now, Zach, and I'm gonna, because I want kids to know this. Like when we say "Let's go, Brandon," Joe Biden can't. The government cannot come after us because of us saying that. Or if we say that Joe Biden's an idiot, the government can't come out after us. Or if we say Nancy Pelosi is that Kamala Harris is a garden tool. Now that's a good one. Yeah, she's a garden tool. If you know where I'm going with that one, they can't come after us for actually saying that. But the government can't come after us if we say something disparaging about the government. They can't do that. They can't sue us. They can't. But yes, that's our First Amendment. We do, and for most things, we can say stuff because people have to prove that we knew it was false. So we do have freedom of speech for most. Yes, deplorable chicken. It's AC again. And hello, young lady. I enjoyed this morning with freaking with Monty. But yes, that's our freedom of speech. We can say what we want about the government and most people are around us. But we are not, if we say something about people around us, we're actually not free from the consequences if we say something bad to them and they knock us out. We're not free from that. That's a whole different story. Zach, to understand where we're going with that, you'll have to go watch Monty's stream from this morning. But that's our first. And now I love this one because I know everyone in here is a gun supports this one. So let me go and actually say what this amendment actually says. The Second Amendment to the Constitution of the United States of America, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So they could have taken everything else out of that Second Amendment. The right of the people to keep and bear arms shall not be infringed. They could have just put that and all of this bullcrap that we see from our government would be null and void. Yes, I know my rights. The right of the people. It says the right of the people to keep and bear arms. So why is it so hard for people to realize that we're crying out loud, Zach even has the right to keep and bear arms? Sorry, Sherry, but I'm very passionate about this amendment. I completely support the Second Amendment. That's me. Mr. Smouse over here, I know he supports it. I know everybody in the chat supports this amendment. So, Zach, let's bring that video up about the Second Amendment. I'm not actually yelling.
Hi, Hi, this is Kim from Khan Academy, and today I'm learning about the Second Amendment to the U.S. Constitution, which states that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. To learn more about the Second Amendment, I talked to two experts. ▴ is a lawyer who successfully argued two landmark Second Amendment cases before the Supreme Court. Adam Winkler is a professor at UCLA Law and the author of Gunfight, The Battle Over the Right to Bear Arms in America. So, Professor Winkler, why did the framers include an amendment on the right to keep and bear arms?
Well, really, there's been some debate over what the meaning of the right to keep and bear arms is, but the most common view, and the view supported by the United States Supreme Court, is that the Second Amendment protects individual liberty, in particular, the right to keep and bear arms for self-defense. Back in the founding era, the framers were concerned about self-defense in terms of armed state militias made up of common citizens who would prevent federal overreach. So the federal government wouldn't be able to run roughshod over the liberties of the people because of these armed state militias. And so the Second Amendment was in part about protecting those armed state militias. Indeed, the fear behind all of the Bill of Rights was that the Constitution gave the new federal government too much power, and the federal government would use that power to inhibit liberty. And so that was the self-defense of the founding era.
When we look at the text, the first thing that people should focus on is the phrase, the right of the people, and in particular, the word the before right. I think that might be actually the most important word in the amendment, because what it tells us is that the right of the people, which is the subject of this amendment, is a pre-existing right. And the fact that this was a pre-existing right tells us that the framers thought that there was something that was out there in their legal system that they were preserving against violation. And in fact, that is the case. In English law, since well before the Revolution, it had been settled and determined that people had an individual right to have arms for self-protection. And this right was understood to enable people to protect themselves both against criminal private violence, as well as the right of people to protect themselves against some encroachment upon their liberties by a tyrant or by a misguided king. This was a right that the framers were well acquainted with in English law, and they were very perturbed that the British, during the time of the Revolution, were violating this right. There were various instances of the British disarming Americans, obviously in an attempt to keep the colonists from revolting and an attempt to prevent them from resisting the king. The Battle of Lexington and Concord, of course, which started the Revolution, was nothing but a British march upon the armories in those towns, in the attempt to suppress the right to arms. And so what you saw was when the time came for a Bill of Rights, you saw 5 out of 7 states propose a Bill of Rights, and the only provisions common in all the demands for a Bill of Rights were the right to religious freedom and the right to arms. Now, the framers were not necessarily concerned about this sort of modern gun control, which is in controversy today.
Today, we have a different kind of self-defense we generally think about with the Second Amendment, and that's about individuals defending themselves against criminals. It's a very personal kind of liberty, defending yourself against someone trying to take away your life, your health, your property, the life of your loved ones. And one thing that I think to remember is that this kind of change in the meaning of a constitutional amendment over time is very common among our constitutional rights, as we take the underlying principles that are embodied in the text and we apply them to modern circumstances.
What about in this early period with the Articles of Confederation? Did state constitutions also protect the right to bear arms?
Yes, there were state constitutions that protected the right to bear arms, most notably the Pennsylvania Constitution. Article 13 of the Pennsylvania Constitution provided, quote, that the people have a right to bear arms for the defense of themselves and the state. And Vermont's Constitution the following year, Chapter 1, Article 15, copied that language. And you would see other late 18th century, early 19th century constitutions keep this language or some version of it. And what you would notice is that this language, of course, talks about the two dimensions of the right to bear arms. The people have a right to bear arms for the defense of themselves. That can only be interpreted as self-defense, and also for the defense of the state. That is, they can use those arms that they individually have and gather together and work to defend the society from some force that's attacking them.
This is really fascinating. So my background is in U.S. history, and I know that one of the reasons that the framers decided that they needed a constitution that would change the form of the U.S. government from what it had been under the Articles of Confederation was Shays' Rebellion, when a group of armed farmers from Western Massachusetts marched on Springfield. So they had kind of taken their military past as a militia in the Revolutionary War and then turned that against the new U.S. government instead of the British government. Did the framers have any reservations about trying to protect militias in light of Shays' Rebellion?
The founders did have concerns about armed militias, as exemplified by Shays' Rebellion. They were worried about self-proclaimed militias, groups of basically armed uprisings in disguise that claimed the mantle of a militia but were really just troublemakers who were taking up arms. And that was kind of how Shays' Rebellion was thought of at the time. And that's why when we think about the Second Amendment, we should focus on that language that the framers were sure to include, which is that the militias must be well regulated. Right? So the Second Amendment itself says a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. And so they understood that there was a militia, common citizens who took up arms to help defend the state and nation. But they recognized that the militia must be well regulated, disciplined, orderly, subject to appropriate command. It wasn't a right for any self-proclaimed group of radicals to get together and grab their guns. It was instead a right to have an orderly state militia, which was an important source of national defense at the time of the founding era.
So I see that the Second Amendment and the Third Amendment, which bans the government from quartering soldiers in people's houses, both reflect fears about standing armies and also the dangers of having very strong government military power. But today we have a very strong government military power and a standing army. So to what extent are those concerns still relevant today?
Well, those concerns are still relevant today. We're very blessed in America that we have a long tradition of civilian control over the military. And in our culture, the military has not been used to suppress the people. That's our experience, but it has been the experience, sadly, in many other places, including through today. And what the Second Amendment reflects is the notion that the government should not have a monopoly on force. There has to be some means that people might still retain the ability to act, to defend themselves, whether that's against a private individual felon miscreant or whether it's against something more nefarious.
Our understanding of what's necessary for national defense is very different than it was in the founding era because our society is so much different. We don't have militias of ordinary citizens the way we once did back in the founding era. And we don't have troops occupying people's homes the way the founders did. But nonetheless, I think the Second and Third Amendment both have principles embodied in that text that remain relevant for today and should not be thought of as dead letters just because the particular concerns that gave rise to them no longer remain our concerns, because the principles they embody are more important and more enduring.
We have been blessed with peaceful transitions of power, with a vibrant democracy. Perhaps at least some aspect of our happy experience relative to those of our friends and ancestors in Europe is that we do have a culture that includes the widespread private arms. And that may have a beneficial effect in making sure that everybody plays by the rules and observes normal political conventions and norms.
So what are some of the major Supreme Court cases that have shaped our understanding of the Second Amendment?
The first one was a case called United States versus Miller that arose in the 1930s. In Miller, you had a situation where an individual was a gangster and he was caught with a sawed-off shotgun, which at the time and still now does require a special tax stamp that Mr. Miller did not have. And he argued that the Second Amendment secured his right to this weapon. The government took the case to the Supreme Court, and at the conclusion of a somewhat confused opinion, the Supreme Court remanded the case back to the district court for a determination as to whether or not the sawed-off shotgun was an arm of the type whose possession is protected by the Second Amendment. Subsequently, Mr. Miller was murdered, so perhaps he needed a gun of some kind after all, but we never got the answer to that question. So I would read that case, as other people do, and say, look, obviously the Supreme Court thought there was some individual right to arms. If the court had held that there's no individual right to arms, it would have been a much simpler opinion. They would have just said so, and that would have been the end of the matter. But instead, because more evidence was needed relating to whether or not this was an arm of the type that Mr. Miller could possess, that shows that there was some right there at issue. Much more helpful, of course, is the case that I argued in the Supreme Court, DC versus Heller, which was a coherent, detailed, fully briefed, and exhaustively opined matter which struck down various Washington, D.C. gun control laws. The main laws at issue in Heller were a District of Columbia law that banned the possession of all handguns by people effectively, and also a law that prohibited people from having operative firearms in their home. You could have a long gun, a rifle, or a shotgun in your home in D.C., but you could never render that operational for use in self-defense inside your home. Oddly enough, you could use it in self-defense in a place of business, just not at your home.
The most important case on the Second Amendment is District of Columbia against Heller, where the court held for the very first time that the Second Amendment protects an individual right to bear arms and struck down a gun control law. That was a very important case, a landmark ruling that has led to many, many, many court cases challenging the constitutionality of a wide number of gun control laws. The Supreme Court has not again stepped into the Second Amendment with one exception. The court in a case called McDonald versus City of Chicago held that the Second Amendment applied equally to the federal government and to the state and local governments. One thing to remember about our constitutional rights is that they don't automatically apply to the state and local governments. But the McDonald case held that the Second Amendment and the principles of the Second Amendment nonetheless apply to the states as well. And that's pretty common as well. Over the course of the 20th century, the Supreme Court has held that nearly all of the provisions of the Bill of Rights apply equally to the state and local governments.
How about limits on the Second Amendment? I mean, I couldn't own a tank, right? What sort of limits may the government place on the right to keep and bear arms?
Well, the Second Amendment, like all other rights, has some limitations. The first limitations are, of course, as with all rights, given to us by the scope of the actual rights. There are many things that simply aren't included in a particular right. The right of free speech, for example, guarantees you the right to speak in some ways, but perjury is speech, terroristic threats are speech, extortion is a form of speech. None of those are traditionally protected. And likewise, there are going to be some arms that are going to fall outside of Second Amendment protection. The Heller case tells us how to go about discovering those limits. The amendment, we are told, presupposes that people will have arms that people would expect to find in common use for traditional lawful purposes. And so while a handgun or a rifle is a type of arm that people would keep for self-defense, for hunting, for sport, a tank or a bazooka is usually not something that you would wish to access for some traditional recognized lawful activity, right? I mean, very few people would use a tank to defend themselves against a mugger on the street, right?
I mean, as a matter of practicality, even if we didn't have a Second Amendment, there's no possible way we're going to disarm the entire civilian population. So the guns are here to stay. The question is, how can we exist with civilian armament and good and effective gun control? And I think that history and tradition can provide some of those answers. In the same way that we try to understand what does the text of the Constitution mean and what are the principles that that text embodies, we look to history and tradition, how have Americans lived under that Constitution over these 200 odd years. We should also look to that history and tradition in seeing the limits of those constitutional rights. And one thing I think is very clear from the history and tradition of gun rights and gun regulation is that there's ample room to regulate firearms. The Founding Fathers had gun control laws. We had gun control laws in the Wild West, even though that was the heart of America's gun culture. We've had gun control laws all through American history, and they're part of the story of the Second Amendment as much as the six-shooter and the right to bear arms.
So we've learned that the framers' concern over protecting the right to bear arms originated in the experiences of the American Revolution, in which militias played a central role in winning independence for the United States. But a lot has changed since the Revolution. The US military has grown, and arms have gotten a lot more powerful. ᖏ suggests that the lack of a government monopoly on force is a key component of the peaceful transitions of power that characterize American democracy. ᖏ, however, argues that there's always been some form of gun control in the United States, even in the Wild West. To learn more about the Second Amendment, visit the National Constitution Center's Interactive Constitution and Khan Academy's resources on US government and politics.
I am going to play this because at the end of that video, I disagree with it, and I need a little help from a former president.
You are fake news.
Because the actual gun laws didn't actually start until the 1900s, the 20th century. That's what most people don't understand. I agree with Polarin. I agree with firearms regulations should be left to the parents, proper teaching young ones proper use and safety. I've been around guns. I'm 41 years old. I've been around guns since I was about 5. That's the first time I ever handled a gun was when I was 5 years old. Do you think I've ever went out and did any of the stupid shit we're seeing on TV right now? But I do understand because they did have, when it was before the bullet was invented, they did have laws on safe storage of gunpowder. Because gunpowder is a very dangerous thing if it's left out in the heat or anything like that. It can blow up. So I understand the rules and regulations with that. But that wasn't until about the 18th. Now, like I said, I love having Devil Dog and Tom in the chat because they are very knowledgeable. And Liberty Lion, gunpowder is very easy to make. That's a very true statement. I mean, Zach, and I'm gonna ask you this: have you ever handled a pew pew? And while he's typing that up, Polarin, I'm not disagreeing with you there, my friend. But as you can tell, I'm very knowledgeable with the stuff that I'm talking about because I have done this research. And Zach, let me know when you're ready to actually, because, but that's the thing about it. We're getting, hey, book girl, but that's why I want people to know about this stuff, because if we know our rights and what the Constitution and the Bill of Rights actually guarantee us, there are things that we will know in the future. All right, Zach.
My first gun I shot was a .22 and I have a nice little handgun if I need it.
And I am gonna say, and I'm very proud that you train with them. You make sure you're very responsible with them, and that's what I want people to know. And I will say this now: if you're gonna go buy one of those things, please get training with it. Please get training, because I want every American that can legally own a firearm to own a firearm and be well trained with that weapon. I don't care who you are. Jerry Lee, you're right. Jerry Lee, you're right. But I want people to be very reliable with their firearms, because if you're a member of a gun organization, I'm not going to disparage any of them. Actually, no, we did. No, we didn't. Book girl, thank you. Thank you. Do you know, Zach, do you know anything of Madison's reason? Because Madison was very fearful when the United States was starting that it would be like Great Britain. If you didn't belong to the Church of England, you couldn't be in politics. Madison didn't want that here. Madison was very careful, but Book Girl, thank you. GOA is a very good organization, but I'm happy Book Girl brought that up, because Madison was very fearful, because as you can tell in the Constitution, it says there are no religious tests. That's why the First Amendment says freedom of religion and freedom from religion and all of that. So it's like you can understand where he was coming from, because he didn't want to have the British laws come over here to the United States, and I'm thankful he did. But Zach, what do you think? Are the First and Second Amendment the most important amendments we have to the Constitution? Or do you think all 10 of the Bill of Rights are very important? What do you think? What does people in the chat think? Are the first 2 amendments the most important, or are all 10 equally as important as the first 2? I want to see what you guys think, because I'm getting in my teacher's mode. because that's why Liberty Lion, the second, protects all of them, actually. Go ahead, Zach.
All 10 are important, but the Second Amendment protects all of them.
Exactly, bud. That Second Amendment, because if we didn't have that, the government would infringe on the other 9. So it's like, because of that Second Amendment, I'm gonna disagree. Exactly. And I want you guys to know this. I want you to know this information because, and please, I'm gonna say this now. Please share these streams that me and Zach are doing with people, because we need people to know what their rights are. This is why Zach and me and him's talked about. This is why Zach has done this every Thursday for the last 2 months or so. We want you guys to know what your rights are. I like Liberty Lion. Yeah, repeal the 16th Amendment. But I want you guys to know that these amendments are very important. That it was about 3 years between the ratification of the Constitution and the ratification of the Bill of Rights, the first 10 amendments. Yeah, Devil Dog, you're right. And we'll get into that when we get down that far, because I have something planned for the 16th and 17th Amendments. But Zach, what have you learned tonight about the first 2 amendments of the United States Constitution? And everyone down there. Thank you, Polarin. That's very helpful. And everyone in chat, what have you learned about the first 2 amendments? The first 2 amendments. What have you learned about them from the stream? Because I am gonna ask this from now on at near the end of the stream, because I want to know. I want to know what you guys think, because these should be as important to you as they are with me. Matrix, I don't think the founding fathers was thinking our government would do that, but that's a whole nother issue. Thank you, Liberty Lion.
We just need to keep fighting because the first 2 amendments protects us.
But please share this out with people all around us. Zach, as always, this was fun. And it does. Oh, before we stop this, I do need to ask one more question. Does anyone in the chat have a question for me or Zach or both of us? We'll give them a few minutes. Zach, you know I'm passionate about the Second Amendment. That was very apparent with my voice. Yeah, Matrix, that's very true too. I will agree with that one. That one I will agree with, yeah. But that If no one has anything, but please, when I sign off on my stream, please be good to one another because we are in this together. And remember, we are in a battle. Go for it, Garrett. Because I do not like the man, and I think FJB is very appropriate for the man. Just saying. What do you think, Zach? Is the FJB appropriate? Devil Dog, I don't know the answer to that question. I do know, Garrett, I will say this since we're going to wrap this up. Jerk chicken is very fine grub.
Hey family, thank you for coming and learning more of the Constitution. We are in this together and we need to stick together and bring out the knowledge so we can eliminate the evil. I love you all and have a great night.
We need you now. We need you now. One day, one day, one day, I hope you see the truth. This puppet show stays on because of you. We've been dancing with the devil way too long. I know it's fun, but get ready to pay your dues. Oh God, come back home. This crazy world is filled with liars and abusers. We need you now before we're too far gone. I hope one day they finally see the truth. God, we need you now.
Good night, everybody.